Hello, thank you very much for coming, and thank you for having us down here in Queenstown. It's been lovely, hasn't it? Yeah, really great. So, the Accredited Employer Work Visa, which has just pretty much started last month. Last month. And it's new and exciting and very, very challenging. There's lots of little teething problems. So, what I thought I would do is give an overview and then talk about the job check process, and Sarah's going to talk about where most people are having the niggles, which is in the employment agreement, and I'll talk about where the recruitment advertisement, that's also where people are having niggles as well. So just to give you an overview, the Accredited Employer Work Visas basically replaced all of the old work visas that we knew and loved so well down here in Queenstown. So the Essential Skills Work Visa, the Work to Residence Visa, they've gone, they've been swallowed up by the Accredited Employer Work Visa, which has got such a catchy name. So what used to happen in one application is now divided into 3 applications. So you've got 3 lots of application fees to pay, 3 lots of applications to deal with, and if you're still functioning at the end of that, you should have a migrant employee. So the first stage is getting the employer accreditation. So that's an online application. It's not too tricky. In fact, they haven't declined anyone who's applied for it yet. And my most recent applications have been approved within 24 hours. So has everybody got accreditation? I know you guys do. Anybody else wants to admit to being accredited? No? What's really good, it's actually not as stressful as I was initially thinking it might be. It's not too bad. I'm going to talk about it a little bit more, but there's a few things to be aware of that you should get set up when you apply for your accreditation. What makes me nervous, and I am a lawyer, so I get nervous about things, is that people will have been getting their accreditation and not have all their systems set up, and then in 12 months' time when they need to renew, there could be some oopsies and nightmarish moments. So that's $1,220 to get your accreditation. Then you apply for the job check. So you go back into your online form, which is really difficult to navigate. I had a client ring me on Wednesday and she was saying, I want to throw the computer out the window, but stick with it, it gets easier in the end. And that's where you show that you've met the labour market check requirements, if you have to. There's the green list exceptions, and that your employment agreement passes muster. And what they've asked for the employment agreement is more than what's required for employment law. They've put an extra layer of difficulty on top. And then, assuming your employer job check is approved, you could then generate a little email that goes through the same online process that goes to the employee. It's basically a token. They then use that token and a link to apply online for their visa. Main things to remember. There are exceptions for the hospitality industry and for aged care pretty much, but everyone else needs to pay at least $27.76 per hour to get a work visa to recruit a migrant. So that's a big change from the past. There used to be a certain type of visa you could get for people earning less than the median wage, but now it's $27.76, which I think is going by okay because we're in a time of great wage inflation, but when it was first proposed, it was quite controversial. If somebody's earning twice the median wage, which is $55.52 per hour, they have a residency pathway. Once they've held that Accredited Employer Work Visa for 2 years, they can apply for residence. The law for that was just published the week before last. They're telling us it's going to take 6 weeks for those applications to process. And I think I saw a pig fly by. There's a green list which has been introduced, and that's because they know that, this is going to come as a big shock. There's a real shortage of people in New Zealand. So there's certain occupations that are on the green list, not enough. They've also ranked the green list into Tier 1 and Tier 2. So Tier 1 is engineers, quantity surveyors and doctors. Tier 2 is nurses and teachers. Interesting division. As I was saying before, there's some strict requirements for recruitment advertising and some pretty gnarly requirements for employment agreements. Does that all make sense? Okay. So, what are the requirements for accreditation? A viable and genuinely operating business. So if your business has been around for 2 years and you've not had a 6 months of loss at any point, you should be able to tick that box, move through. If you've got a new legal entity or you're newly arrived into New Zealand, you're going to have to show you've got some capital or funding or support from an overseas entity. That means you're going to be able to pay your wages and keep operating, like pay for your stock, your inventory. Again, it's not too onerous. You've got to provide settlement support information to employees, and there's a list of the information you need to provide them, and you need to provide it to them pretty much before they start work, or just as they start work, and that's things like how to get hold of the Citizens Advice Bureau, how to open a bank account, how to get an IRD number, what is transportation like in New Zealand, what are the options, what's the cost of living, the industry that you're working in, what sort of hazards might they encounter, what are specific job hazards that they may encounter, how do they get hold of healthcare. I think I've actually covered them all. So you should have that. If you're accredited, you should already have that prepared, and you need to make sure that it covers off all of those lists. It's actually a great document to have to give to people to say, welcome, here's how you get your IRD number, because they're probably going to come to you anyway and ask you. So if you can do all that, you might save yourself some time. The other thing is that they've got to complete employment law modules within their first month of employment, and they must do that during ordinary hours of employment, and they must be paid to do it. The common question I get, which I know is on the tip of all your tongues, is what happens if they refuse to do it? Well, as long as you've offered them the opportunity to do it, you've given them the time to do it and actively encouraged them to do it, and you've got evidence of trying to achieve that, then you're not going to die in the dirt over that. So if you can show that you've done it, and we'll talk a little bit more about that, Sarah's going to talk about that. Anyone who's responsible for recruitment in your organisation needs to also complete the employer side of those online employment law modules. One of my clients said to me, if I have my staff complete those modules, they'll start agitating. I thought, I don't think so. So they're pretty basic. I wouldn't be worried that they're suddenly all going to be picketing at the front door. When you fill out the online application form, for accreditation, you have to tick boxes saying, basically, there's one of the questions refers to the Slavery Act, the slavery provisions of the Crimes Act. Basically, if you've been investigated or been found being penalised by the Labour Inspectorate or lost in the ERA for not adhering to basic employment law requirements, you may have to declare that, and you might need to speak to Sarah so we can make sure we haven't got a problem. And the other thing to look, and if you've had somebody work for you unlawfully in the past, which a lot of it happens to the best of us, but certainly happened a lot in the 2 years following the lockdown, because the government keeps saying, we're automatically extending your visa, and it became, and then they didn't send out emails, so people didn't know whether their visa had been extended or not, and just hope for the best and keep going to the work. So there's been a few of those. So if that's happened, all you need to do is show that you've put in place a system to make sure that that won't happen again, and you should be tickety-boo to get your accreditation. The other thing to think about is whether you get standard or high volume accreditation. So standard only costs $740, but it means you can have 5 migrant employees with accredited employer work visas at any time. If you go up to $1,220, which is for high volume, $1,220, you've got no limit about how many you sponsor. And given uncertainties of the times, unless you're absolutely certain you're not going to have more than 5, I'd get the high volume. And you need to identify who are the key people in your organisation. It's actually the first question on the online form. and that will automatically be the directors of a limited liability company, but it will also be anyone who has control over whether the business is compliant with employment or immigration law. So it might be your HR manager, it might be an operations manager. So, and you'll need their date of birth, full name, what country they were born in, and what country they're a citizen of. So it actually doesn't take that long. It's not as bad as I thought it would be. It's okay, but it is a little bit finicky. Does that all make sense? Yep. Okay. Then we get to you've got your accreditation, and you want to hire somebody lovely from Uzbekistan who's going to turn your business around, make it a sparkling success. So, what do you do with the job check? The first thing to think about, I think, is the ANSCO code. And I know I've stood in front of people and said the ANSCO code is dying, but it's back, it's still important. Do we all know what the ANSCO code is? Yes, yes. Just for those who have run out of the will to live and can't nod. I will say it's called the Australian New Zealand Standard Classification of Occupations. So the beautiful boffins in the Australian Statistics Department and the boffins in the New Zealand Statistics Department got together. They classified all the jobs in the world, and then they ranked them from 1 to 7 and put a little description beside each one. They can't imagine all the jobs in the world, and particularly for jobs down here in Queenstown, there's a lot of things that don't even fit into ANSCO. So you have to still try and work with it, because when you do the job check, if they decide that what you're applying for a job check for permission to employ matches with the particular ANSCO, and you haven't asked for the minimum requirements in the ad, decline. So just bear that in mind, keep the ANSCO, and also it's quite important if you think the person might be on the green list or you're trying to get an exception for the minimum wage requirements. So sadly, ANSCO is still there. There's really strict advertising requirements, which I'll talk about in a minute. And then there's really strict employer agreement requirements, and you have to upload the employment agreement. It's got to be a generic employment agreement. It shouldn't have the person's name on it. It's very confusing. They've said 2 different things on what they've published online, but it's just the generic employment agreement. So with the recruitment ad, it's got to include a job description. So what I often see in ads is, you know, are you excited by the prospect of such and such? Come join our team as a such and such. That's probably not going to be enough. You need to put in a sentence saying you will be making such and such a widget and attaching it to our sparkling machinery, which is the best in the world. You just want to give it a little bit more detail so people know what you're talking about, what they're going to be doing. You've got to put in the minimum and maximum pay. And it can't be, you know, in the good old days, if you advertised on Seek, it would band it. So you wouldn't actually have to put in the ad what you're going to pay. It has to be in the ad. Otherwise, the job check will be declined. So that's blown. And it's so unusual in New Zealand. So it's a big change. You've got to put in the minimum guaranteed hours that they're going to work. So it's basically they need to know before they apply what they're going to earn. Absolute minimum. And you've got to refer to what experience and qualifications are needed, and it's got to be what's absolutely necessary to do the job. I mean, it's always been that case, but they're going to be quite strict about this. So if you know, don't ask for a qualification that is a particular qualification if there is something else in the world that could do it. You know, I'm trying to give an example. Like, don't ask for level 4 in telepathy from the Bangalore Polo Club in Christchurch. It's not going to be enough. You could say in level 4 qualification or equivalent experience in telepathic thought, for example. And you must make sure the job ad is closed before you apply for the job check, because they will also decline it. So you can't just have a continuously running advertisement like we used to do. So you have to have a separate ad and you've got to close. Now, I say this, you can use one job check for several jobs, for several vacancies, as long as your advertisement makes that clear. As long as all of the jobs that are vacant are the same job and in the same location. So you can't use one ad with 3 different jobs in it. You see what I mean? That's what we've been learning. And and then get your job check in, and hopefully, if your employment agreement meets the minimum requirements, which Sarah is going to talk about, you'll be home and hosed.
Thanks, Nicola. So the employment agreements have taken on quite a bit of importance with these job check applications, and we've seen a few come back, and so we know that they are being scrutinised. So if you're employing staff already, you'll hopefully be familiar with employment agreements, because all employees must have a written employment agreement already, and there are some clauses that must be included in all employment agreements, regardless of whether you're employing a migrant or a New Zealander, and I'll talk about what those are in a minute. But with this employer accreditation process, there are some extra requirements in the employment agreement which we're not used to necessarily when we're drafting employment agreements, but do need to be included. So it is worth taking the time to have a look at your employment agreements and in all likelihood tweaking them a little bit to make sure that they are fit for purpose and, more importantly, compliant. Because obviously if your employment agreement gets sent back or declined, then there's just a further delay in the application process. So the first thing that needs to be included in the employment agreement, as Nicola was saying just before, with the job advertisement, is the minimum guaranteed hours of work for that employee, and it has to be at least 30 hours per week. So the employment agreement must state those minimum hours. Of course, the minimum hours can be higher than 30, but they cannot be less than 30. Along with that is the hourly rate that the employee is going to be paid. And Nicola was speaking at the beginning around it needing to be, unless you fall into one of the exceptions, at least $27.76 per hour. And so sometimes you need to look quite closely about how your hours of work clause and your pay rate go together, because that's where most of the issues arise. So, for example, you might have, so all employment agreements need to have an hours of work clause. So that's a clause that states these are the hours that we're going to need you to work. Traditionally, we've drafted those quite flexibly, which says, well, we'll probably be asking you to work about 40 hours, but we might ask you to do a few more or a few less, depending on how busy we are. So that's not going to work for employment agreements under this employer accreditation process. As I said, you have to have minimum hours, but also what you have to have is your maximum hours. So that's not a legal requirement for anybody who's not a migrant worker, and that's a new thing. Maximum hours means maximum hours, and that you cannot require or even ask your employee to work any more than the maximum hours stated in the employment agreement. So you do need to give some thought about what those maximum hours might be. Think of your busiest possible time and how many hours might you be requiring somebody to work at a maximum, bearing in mind also your health and safety obligations and so on and so forth. Your maximum hours also ties in to the rate of pay when the Immigration New Zealand are looking at your employment agreement and assessing whether you're meeting the minimum pay requirements. So your employment agreement can deal with pay in all sorts of different ways. Probably the simplest way of dealing with it for the employer accreditation purpose is to simply have an hourly rate, a flat hourly rate that's $27.76 or more for each and every hour that the employee is going to be working for you. You're not going to have any issues or problems if you do that. Where it can be a little bit more complicated is if you're employing somebody on a salary, and it's at that stage that you need to make sure that you're pitching your salary at the right level. So the way that Immigration New Zealand will look at it is that they will look at what your maximum hours in your contract are. They will look at what the salary is. They'll just do that quick division, and they'll check that it's more than $27.76 an hour. If it's less than that, then employment agreement will be declined and sent back. If it's more, you should be fine. So it's well worth taking some time to have a look at your hours of work clause, to have a look at your pay clause, and just make sure that you're tailoring it for what your needs are. There's not really a one-size-fits-all clause that you can, just Google and will work for every situation. The other important thing to note, which must be included in the employment agreement, and again, we've had clients with employment agreements that have been knocked back because they don't address the issue of overtime in the employment agreement. The employment agreement must state whether overtime is payable. It's not a legal requirement to pay overtime, but you have to say whether overtime is going to be payable or not, what the rate of overtime is, and when overtime kicks in. So your employment agreement has to address all of those things. The pay period has to be, this is the frequency that you pay people, has to be no more than 1 month. Generally, that's not a problem because most employees in New Zealand are paid either weekly, fortnightly, or monthly. All of those options are fine, but you can't pay less frequently than monthly. Touching on the point that Nicola made in terms of making sure that you're not imposing requirements that you actually don't need for the job. So things like requiring an employee to have a full driver's license or a New Zealand driver's license is not going to be acceptable unless the job that you're employing them to do legitimately requires driving. So if they're a truck driver or something like that, clearly they're going to need to drive. But if they don't actually need to drive as part of their job, you can't require them to have a license as part of the role. You've got to have a think about sleepover arrangements, if depending on the type of job that you're asking people to do. So a sleepover arrangement is where somebody is sleeping over and has some responsibility for people during the evening, but they're allowed to sleep as well. So it doesn't cover, for example, the situation like what Nicola and I are doing at the moment. We're coming down for an evening and we just happen to be spending the night. That's our own time. That's not a sleepover arrangement. But if we're working on a school camp and we've got responsibility for kids overnight, for example, then even though we can sleep, we're on call, we're responsible. That's a sleepover arrangement, and you need to make sure that you are paying people at least the minimum wage for a sleepover arrangement, and that they're getting their 30 hours, they're guaranteed 30 hours on top of any sleepover arrangements. You need to deal with relocation costs if you run a business where employees might be required to work at different sites. Most commonly we're seeing that in the construction industry, where people might be working on a particular site, that project finishes, and then they might go to a different part of New Zealand or be asked to go to a different part of New Zealand to work on the next site. You need to make sure there's a legal requirement that employees are not disadvantaged by needing to travel, and we'd recommend that your employment agreement expressly addresses any travel requirements. So for example, what you need to provide is how much notice you're going to give employees of the need for them to work at a different site, what support you're going to give them if you need to relocate them, for example, paying for accommodation costs, paying for relocation costs, those sorts of things. So we'd usually recommend that you have a tailored clause in your employment agreement for that, which would be not the type of clause that you would normally see in an ordinary employment agreement. So something really quite specific for this. So the employment agreement has to contain all the mandatory clauses that all employment agreements need to have. So that's obvious that it wouldn't be anything less, and it can't contain any clauses that are illegal. Also, that sounds obvious, but just drilling into some of the detail about what some of these illegal clauses might look like that we do actually see from time to time in employment agreements. Things like bonding clauses. I'm not sure if you've seen those or in employment agreements. So a bonding clause is a clause in the agreement that says, we'll pay for this, but if you leave within a year, then you've got to pay it back, basically. So bonding clauses are not illegal, they are lawful, but there's only certain things that you can require employees to pay back. And there's a whole big long list of things that you can't bond employees to. So things like anything to do with their induction, anything to do with health and safety, anything to do with the costs that you've incurred in recruiting them, inductions, those sorts of things. So you you can't bond that, which can present difficulties when you're spending a lot of money bringing a migrant worker over. But if that employee resigns, which they're entitled to do, then you've got a whole load of unrecoverable costs. So just sort of be careful around some of those clauses in employment agreements and check that they are not unlawful. And just bear in mind that Immigration New Zealand take really, really close look at those types of clauses, because they're very concerned with the potential for migrant worker exploitation. And one of the ways that that's happened in the past is through employers making unlawful deductions, too many deductions for too much stuff from people's wages. So be careful around that. So bonding clauses and anything that's around deduction of wages, make sure that that's lawful and reasonable. So this is just a little refresher on the clauses that all employment agreements in New Zealand need to have. So this isn't particular to the Accredited Employer scheme. This is for everyone, but it's good to ensure that we do keep those in mind. And actually, even I have a little checklist sometimes when I'm reviewing an employment agreement, just to make sure they're all in there. First and foremost, actually quite often forgotten, the name of the parties, and more particularly the name of the employer party. It is a legal requirement and needs to be in there. The pay we've already covered, the hours of work we've already covered. A description of the work to be performed, basically that's your job description that you have in your employment agreement. That also is, you've provided some details of that as part of the job check and the job advert, but you have to have a job description in there. The location, so where the employee is going to be based for work, where they're going to be working. Is it Queenstown? Is it going to be more widely than that? Is it going to be your particular office address? So that has to be specified in the agreement. All employment agreements, you have to have a clause that says you get time and a half if you work on a public holiday. And all employment agreements have to have what's called an employee protection provision. So that's a clause that talks about what the employer is going to do if they sell the part of the business that the employee is working in, and what negotiations they're going to have with a potential buyer about hopefully keeping them on and them being offered employment. You've got to have a clause dealing with employment relationship problems that says you've got 90 days to raise a personal grievance. And you've got to have also information about what employee entitlements are under the Holidays Act, and that employees can get further information from a union if they're a member, or from the MBA website. And we often just put a little link in the employment agreement so that people can click through. Again, I don't agree with Nicola. Letting employees know what their minimum rights are is hopefully unlikely to cause strife in your business. Then just finally, once you've got your employment agreement over the line, don't sort of snatch defeat from the jaws of victory sort of just at the end. And particularly this is going to be relevant probably after 12 months when you go to get your reaccreditation, and you might get a bit more of a thorough check of your documents at that stage than perhaps you have now. So there's a few things that we recommend. The first thing there is it's not a legal requirement, but it's just quite a good way, we think, of being able to demonstrate compliance with some of the requirements. So Nicola talked right at the beginning about what the obligations are, about providing information about settlement support, how you get your IRD number, how you can get accommodation, those sorts of things. So you can put a clause in your employment agreement essentially confirming that you have provided, the employee acknowledges that they have been provided with that information. Similarly, you can put a clause in your employment agreement where the employee acknowledges and agrees that they're going to do the modules that they need to do, those employment modules within the first month of their employment. Again, often a good idea to have some policies ensuring that people who are responsible for the recruitment decisions, your HR managers or your business owners who are making the recruitment decisions, have a policy, or that it's clearly documented that they also have to do their employment modules as part of the process. You have to have a policy or a process to track hours of work and pay. So again, that's not new because it is already a legal requirement to have wage and time records for all employees, so shouldn't be new or shocking for anybody. But I think there's going to be very much more scrutiny on migrant workers to ensure that those proper wage and time records are actually being kept, and they're going to be used to make sure that you're meeting those minimum pay requirements, not going over your maximum or your minimum hours of work. And then also, there's not something specific to migrant workers, but very, and that this is good practice to do regardless, but having some documentation around your reasons for either accepting or rejecting an applicant. Though it's a bit of a dark art. You don't want to be writing down pages and pages of stuff about why somebody's unsuitable, but you don't want to have nothing either. And obviously you want to make sure that your reasons for declining are genuine and business objective, genuine objective reasons, not anything that might be discriminatory. I'm just going to hand back to Nicola now to complete the piece about your employees. Here we go.
So I just wanted to sort of wrap up and talk about, other things to think about once you've got the job check through. So you've got your job check approved, you've gone online, you haven't thrown the computer out the window, you've managed to send them the token they need to apply for their visa. Do make sure that if they're going to bring family, that they think about it now, because the government is proposing that from December, anyone earning less than 55, 52 won't be able to bring their families on a work visa to New Zealand. So what's often the case is that mum or dad come out first, the other partner stays behind and looks after the cherubs. Then once the first parent's got everything set up, the other parent comes out with the kids, has a torturous plane ride, and then they finally start their lives together. They need to think about that now, perhaps moving things forward. What we've been doing is when we're starting the job check process and we're acting for employers, we're also acting for the employees and saying, let's get those police certificates and medical certificates underway now, because there was a pandemic. It can be difficult to get appointments with doctors abroad. There can be delays. So it was a nightmare at one point to get police certificates because all the embassies and things were not operating, but that's much better now. The need to be COVID-19 vaccinated is still applicable to come into this country. So they, if they've got any family members who are not vaccinated, who need to be vaccinated, it's better to find that out right at the beginning of the process. That may change, but at the moment it's still the case. Think about your current employees, because the government extended people who have got the Partner of New Zealand work visas and Essential Skills work visas for 2 years with on open conditions. So, and again, just like happened through the pandemic, not all employees got an email confirming that, so ask them to follow up. A lot of those emails go into junk on Google Mail and Hotmail accounts, so just make sure, because you don't want to have to go through all of this if you don't need to, if they've got a 2-year visa. Because I suspect, I hope, that some of the things we've been talking about today in terms of maximum hours on an employment agreement and working out the minimum hourly rate, I'm hopeful that the government will tweak that for people earning above a certain level at least. Because, I've been on phone calls with people who are employers who regularly pay people $150,000 per annum, for example, and they're like, jeepers, we expect those people to work more than 30 hours a week. So, and as I was saying before with the ANZGO, make sure that they're able to prove that they've got the 3 years experience or their qualification is recognised in New Zealand. And if it's not, and they need to get an assessment by the New Zealand Qualifications Authority, they need to get that in now, because that's taking a minimum of 4 months to get that through. The normal way around that is to prove you've got the minimum equivalent work experience, so they'll need to be getting letters of reference that are signed from their previous employers. And as I was saying before, think about your advertising requirements. Make sure, if you've advertised, you might have to do it again and have a look at what you've been, what you've done in the past, and make sure the ad's going to meet that requirement. And also think about the residence process. So if you've got anyone that's earning 55, 52 per hour and they're going to be on that 2-year pathway to residency, they've got, when it comes to applying for residence, they'll need to prove that they earn that 55, 52 per hour. And if they work more than the maximum hours stated in the employment agreement and they can't get their residency, your accreditation is going to be on the line, but you're also going to have a really angry and upset employee because they've lost their chance for residency. So when you're drafting those employment agreements, really think about what the maximum hourly rate's going to be and try and calculate it. Or if you can't afford it, make sure that there's some policy or process in place so people don't work more than they need to, because it might catch up with you 2 years down the track. If that makes sense? Yeah. So any questions? No questions? I'm getting phone calls about I've been locked out. How do I get hold of sort out my real me? You have to go down to AA and have your identity verified. And the lady I was speaking to is, I think she'd lost all. She said it's 10:30 in the morning, but I don't think it's too early for wine. So, has anybody got through a job check yet? Yep, and all approved and.
Yeah, so we've had 4 approved. I've had 1, I haven't had a chance to actually click into it today, but I saw an email pop up asking for more information.
Ah, okay.
So I'm intrigued to see what that one might be. I think it could be one that doesn't exactly, most of our jobs are titled the same as the ANSCO code, but this job is titled different to the ANSCO code.
That's interesting.
It's the ANSCO code that matches that job best.
Okay.
So I think it could be that.
Yeah.
Yeah, but ours only took 3-4 working days.
That's great, because I had one that took 5 weeks. I was talking to an employer, they put in exactly the same employment agreement, one that didn't meet any of the requirements we talked about, on 2 job checks, redo your employment agreement, the 3rd one approved. So, yeah. And INZ, just like everybody at the moment, is understaffed and overworked. So there will be areas that work in employers' and lawyers' favours, which we won't signal. But there will be ones that are actually wrong, and we've seen a few of those. So don't be afraid to go back and question and say, look, from the guidance that I've seen, this is right. And you often will, and do it politely, because they're very nice to you if you're polite. They're used to grumpy lawyers. You might find that you get the right outcome. Any other questions, or just want more cheese and wine? Okay. All right. Thank you all very much.